Ms. Sylth is currently in a Ferguson gown and handcuffed behind her back in this hearing, which this is atypical. This is not typical. I don't know what's going on. I can only surmise unless someone wants to tell us what's going on.
Good morning, Ms. Sylth. How are you?
Good morning.
My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Justice Sylth, 399-254. Today is Friday, August 30th, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
Justice Monier Sylth, 399-254.
This is a public hearing. Present this morning is P.O. Goodman, as well as your attorney.
Good morning, Public Defender Robert Famigletti of the Parole Revocation Unit. Hello, Justice.
Hello, Rob.
Good morning, Justice. Kimberly Goodman for Parole and Community Services Mental Health Unit.
Hi, Kim.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. Yo, Goodman, you're not muted.
Oh, my apologies. Sorry.
If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement.
Welcome to today's courtroom breakdown, where the tension is palpable and every word holds weight. This is the revocation hearing of Justice Sylth, who stands accused of multiple parole violations that could keep her locked up for years to come. But what led her to this point? Why is she appearing in a Ferguson gown, handcuffed behind her back, and what does it say about her situation? Stick around, because we're about to dive deep into the case, unpack the evidence, and explore whether these allegations truly justify a total revocation of her parole. And trust me, you won't want to miss the twists ahead. This hearing is far from routine. Are we about to witness a miscarriage of justice? Or is this exactly the outcome she deserves? Let's find out. But first, don't forget to hit that like button if you think this case is a ticking time bomb, and subscribe so you never miss out on these high-stakes courtroom dramas.
The testimony at today's hearing will be taken under oath. P.O. Goodman, in this, I'm going to actually ask that your attorney can you raise your hand for her? I mean,
Are you both of your hands down, Miss? Okay. So, I can't do it.
You can do it,
but you can at least say that you. Okay.
Okay. So I'm going to just place you under oath. Okay. So I was going to make this say yes at the end as long as you're in agreement.
Okay.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your officers bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
Thank you.
Can I just ask, Justice, are you okay? You look like you're in a lot of pain.
Oh, I'm handcuffed by the back from this chair. I could move up a little bit, be more comfortable. I'm not in a lot of pain. I'm just expressive based.
Okay. I just wanted to make sure you're all right.
We now review the charges of the state your officers bringing against you and the information underlying each charge. P.O. Goodman?
Yes, ma'am. Charge number 1, release direction. Under program participation, you were placed in mental health Connecticut Parkview supportive housing program. Upon admission, you were issued a handbook outlining the program's rules and regulations. You signed acknowledgement forms agreeing to abide by said rules and regulations. As a result of your willful violation of these rules and ongoing, escalating, and dangerous behavior, you were unsuccessfully discharged from the Mental Health Connecticut Parkview program, which was funded by Demas on April 25th, 2024.
All right, let's start with the first charge, program participation. Justice Sill's behavior has escalated since her placement in the mental health program. Now, this isn't just a minor infraction. According to the state's argument, this is a pattern of willful violations that has culminated in her being discharged from the program. But here's the kicker. She signed the rules, agreeing to abide by them. So the real question is, did she really have any choice in how she reacted? Or was this a result of the system setting her up for failure? Do you think she should be held accountable, or is this a deeper systemic issue? Let me know your thoughts in the comments below.
Charge 2, obey all laws. Since your admission, obedience to the law, since your admission to Parkview Supportive Housing Program, you have caused significant damage to your assigned apartment. Damage includes numerous holes in the walls, drawings and writing on the walls, unsanitary conditions, and possessing contraband. Your behavior meets the threshold for 53A-11-6 criminal mischief in the second degree. On 4/20/24, you entered the staff office at Parkview Housing Program for your medication. You proceeded to enter the back office and take program supplies. When redirected to put the items back, you punched the wall, then proceeded to smash a flower pot on your way out of the office. Your behavior meets the threshold for 53A-11-7 criminal mischief in the third. On 4/22/24, while meeting with your staff member, you saw another program participant and shouted at him. The other resident continued walking. You ran out of your apartment with a metal bat. You chased the other resident and hit him in the arm with the bat. Police were contacted and you were issued a citation for disturbing the peace, which carried a $109 fine. On 4/23/24, you came to staff and reported that you had broken a window in the apartment intentionally by throwing a chair at it. Your behavior meets the threshold of 53A-117 criminal mischief in third. On 4/25/24, you entered the staff office to use the phone. At 7:45 a.m., you became agitated and bent the staff office phone, breaking it. At 8 a.m., you ripped the door off your bathroom vanity and threw it from your apartment door into the community circle. At 9:45, you were observed by staff kicking in your apartment door. You kicked it so hard you cracked the frame, and the door was no longer able to close. At 10:45 a.m., you flipped the community circle picnic table when leaving the property, causing it to be damaged. At 2:45 p.m., you were observed throwing a bag into the community circle. It was filled with glass and garbage. You were observed spreading the glass and garbage in the parking lot. These behaviors meet the threshold of 53A-117 criminal mischief in the third. D, drugs. On 3/18/24, you tested positive for cocaine on an oral swab. The swab was sent to Premier Biotech Labs for confirmation, and the positive result was confirmed. As a result, you are in violation of release direction, obey all laws, drugs.
The state has filed the following exhibits, starting with Exhibit A.
I'm sorry, one moment, please. Exhibit A, I don't actually know. Oh, yep. Exhibit A, signed parole conditions. Is Exhibit B, remand.
So now we're looking at the criminal mischief charges, and these aren't just minor offenses. We're talking about $200 worth of property damage, including smashed flower pots, broken windows, and even a door frame kicked in so hard it couldn't close. These aren't just tantrums. This is aggressive destruction, folks. The state is clearly drawing a line here. Her actions threaten the safety of both the community and herself. What do you think, though? Was this pure rebellion, or was she pushed to the edge by a system that failed to support her properly? Would you have reacted the same way in her shoes? Drop a comment and let's discuss.
To actual custody order. Exhibit C, notice of parole violation, parolee rights. Exhibit D, parole violation report. Exhibit E, Demas critical incident submission form 4/22/24. Exhibit F, Demas critical incident submission form 4/25/24. Exhibit G, mental health Connecticut discharge letter, behaviors of concern list. Exhibit H, mental health Connecticut residential services handbook and signed acknowledgements. Exhibit I, photos of property damage on 4/25/24. Exhibit J, photos of apartment damage and disarray since admission. Exhibit K, positive drug screen and misconduct. Exhibit L, MHC video footage 4/22 incident located on the X drive. Exhibit M, criminal mischief second and third descriptions, and Exhibit N, previous revocation summaries and hearing dispositions.
Let's pause here for a moment to dive into the legal intricacies. The state has submitted numerous exhibits, photos, incident reports, even drug test results. But what stands out is how this hearing is unfolding. This is a legal chess match, with both sides presenting their arguments, but the hearing examiner is weighing whether the state's evidence holds up under scrutiny. And remember, the burden of proof is on the state to show, by a preponderance of evidence, that Justice Sill violated her parole conditions. But the defense, as we've heard, claims that some of these allegations are vague and the rules themselves weren't clearly defined. What's your take? Do you think the defense will be able to tear down this case, or are they fighting a losing battle?
In June 2024, the state filed an addendum to Exhibit D, which stated on June 11th, 2024, that Silk was served a warrant and arraigned on charges of breach of peace second and criminal mischief first for her behaviors that occurred on April 25th, 2024. At such time, probable cause was established. The state submitted additional evidence that was not available at the time of the preliminary summary. At the time of the preliminary summary was completed. Addendum evidence consists of Exhibit A, authorized arrest warrant, Exhibit B, continuance of minimus, and Exhibit C, judicial branch pending case detail. In August 2024, the state filed an additional addendum to Exhibit D, which states on August 6, 2024, Ms. Silk was found guilty of breach of peace second and sentenced to 90 days jail, and the charge of criminal mischief first was nollied. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, I have.
And defense has filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, and Exhibit 2, letter of support. Today, we have no witnesses, and at this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. Feel Goodman?
I, with all due respect, I think the charges speak for themselves. I would much rather like to save my commentary for history and background.
At this time, the state will, or the defense, it is now the defense opportunity to present evidence to speak to any of the evidence submitted.
Yes, I have no comment regarding the preponderance charge for charge 3, the preponderance standard. As to charge 1, the allegations are conclusory, just says rules violations, discharge from housing for rule violations, essentially.
Now, the tension's rising as we hear from the defense. Here, we get a stark contrast in perspectives. On one side, we've got a parole officer pointing to escalating behaviors. And on the other, a defense attorney arguing for leniency, citing her mental health struggles and the difficulty she's had finding an appropriate placement. The defense claims this is draconian punishment for a series of minor violations and that she should be given a chance at rehabilitation. But the prosecution has one crucial point. Her behavior isn't just bad luck, it's a pattern. How much does mental health play a role in her behavior, and how much responsibility does she bear for her actions? Let's get your thoughts in the comments below.
I just think that that's not specific enough. So I don't believe it meets the preponderance standard as to charge 2. The only charge that she pled guilty to was the breach of peace, and the second degree received 90 days, and all the other charges were unsubstantiated. No pleas resulted. Thank you.
Charge 1, program participation. I make a finding based on state's exhibits A, D, E, F, G, H, and L. On charge 2, obedience to the law, a no finding was made on parts 1 and 3 when the preliminary summary was completed on May 14th, 2024. Therefore, these charges will not be considered at today's hearing. On May 14th, 2024, a no finding was made on part 5 when the preliminary summary was completed. However, the state submitted additional evidence that was not available at the time the preliminary summary was completed. Given the additional evidence, I make a finding on parts 2, 4, and 5 based on Ms. Silk's conviction, as well as state's exhibits A, D, and F, as well as addendum exhibits A through C. On charge 3, drugs, I make a finding based on state's exhibits A, D, and K. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. First, we're going to start with Theo Goodman. Would you like to make a statement regarding Ms. Silk's background and history at this time?
I would. Thank you so much. We've been working with Ms. Silf since 2017. We have attempted to place her in several community program options, and those have been unsuccessful. The last two options were the Parkview program, which is funded and paid for by Demas. And in order to get Ms. Silf into that program, on both occasions, we had to take her case up to the Department of Mental Health and Addiction Services Commissioner's office in order to find appropriate funding and housing to keep the community safe and to keep justice safe as well. Because of her ongoing and continued behavior, she has made it almost next to impossible to place her in any DOC funded programming, which is why we have to have specialized programming. And this specialized programming takes quite a while to get. This is her fifth violation. She has received sanctions anywhere between 6 and 9 months, and we have utilized in the field that time to secure appropriate placements for her. However, those placements don't really seem to be to Miss Silt's liking, and subsequently she sabotages those placements by acting out in the ways that are described in this violation report and in the ways that are described in the previous revocation summaries. We've attempted to place her in a halfway house where she committed an arson by burning things in the trash can.
Now let's talk about the personal side of this case. The defense paints a picture of Justice Sill as someone who's struggling with boundary issues and an addiction to cocaine, but also someone who feels trapped by the system. Her own testimony highlights the real toll this has taken on her. She admits she's responsible for the damage, but also points to the pressures of living in a system that she feels doesn't accommodate her needs. Do you think she's a victim of circumstance, or is she just failing to take responsibility for her actions? Let me know your thoughts. This is where the heart of the case lies.
She was involved in another halfway house in a sexual assault, which was a Priya incident. She's been arrested multiple times for indecent exposure, for interfering with an officer, assaulting an officer, and grabbing his taser, attempting to grab his taser, excuse me. And her behaviors continue to escalate. You saw in the video that she actually went after someone with a baseball bat when they weren't responding in the way she wanted them to respond. I see that I did receive her report for her parole accomplishments, and it said that she had gone to Stonington for 3 days. Well, Stonington is not a 3-day program, and in 3 days you're not going to address an addiction to cocaine. And as a matter of fact, I quoted in my report that the only thing she got out of that program was a smoking habit. So she didn't successfully complete that program. So it's essentially a bit misleading, that report. It indicates that she's amenable to any treatment, amenable to any placements, but it hasn't mattered where we've put her. She doesn't actively engage in treatment. At times, she's refused to take medications. We do everything in our power to actually help her move on and get to where she wants to go. But she does things intentionally, as she admitted to myself and Officer Montoya, to get out of situations that she doesn't want to be in. I get that it's not easy to be on supervision and that you don't want to be supervised, but in order to keep the community safe and to keep justice safe, there's certain steps that we have to take, and we can't keep somebody out in the community who would cause that kind of damage and destruction to their own apartment. And quite frankly, an apartment that she wasn't paying for. If you were to revoke and reparole her, we would need quite a bit of time in order to secure a more appropriate setting, because halfway house placements haven't worked. treatment programs haven't worked. She was at Blue Hills. That didn't go well when she wasn't getting her way. She threatened not to eat. There's just a plethora of sorry, I got tongue tied for a second. It's just there's a lot of moving parts that we have to address in order to keep the community safe from her and to keep her safe from herself.
Counsel, do you wish to make a statement regarding Ms. Sills' background and history at this time?
Yes, I do. My client is 38 years of age. She's divorced. She reportedly attended Middlesex Community College online studying psychology, and she's about 2 courses shy of earning her associate's degree. For her disability, she receives Social Security. She has a history of psychiatric hospitalizations. While placed, she was sent many visits to the hospital for ideation, and she was released without care. She was placed in the past in female housing and mixed housing, and she states that that's more successful for her. She, unfortunately, when she's placed at DOC, she has to be segregated and is placed with males. Many males approach her.
What's clear here is that this isn't just about the incident in question. It's about a long history of parole violations and issues. The defense argues that it's not fair to focus solely on these isolated incidents, and they ask whether a full revocation is really necessary. But the state's position is that her actions have been progressively worse, and they're building a case that her behavior is a continuing threat to the community. Is there ever a point where rehabilitation outweighs punishment, or do the authorities need to draw the line before it gets worse?
And that makes it difficult for her. She's been incarcerated now for over 4 months for the discharge for housing rule violation, damaging property for which she served 90 days, and 1 positive cocaine urine within a supervisory period of 10 months. She received no graduated interventions and sanctions, and they are recommending that her parole be revoked and reviewed annually. I don't believe that's appropriate. I think it's draconian. She is disabled. She does carry. We are only talking about a period on the 20th of April, 22nd of April, 23rd of April, 25th of April. Those are the dates, and 1 positive urine from March 18th. She has been with parole on this period of supervision since June 23rd of 2023. Like I said, 10 months, just those isolated incidents. She has a history, as I said, hospitalizations. She was on the job waiting list at Osborne Correctional. She wishes to return to Middlesex Community College to study psychology. She's also interested in learning Spanish. She cannot work due to her disability. Justice, where do you wish, or does it not matter? You just want an appropriate placement. Does it matter where you're placed, or you're just seeking an appropriate placement?
I can't speak unto what I think would be appropriate because like nothing's worked so far.
Okay.
I feel like if I was
Is there any particular area, or does that not matter?
for area, I prefer New Haven, Bridgeport, or Danbury.
But you do understand that it may be difficult to place you.
Why?
Now we reach a pivotal moment. The defense claims that Justice Sill's behavior is a result of an environment that failed her, that she's been pressured into a corner by her living conditions, feeling isolated and vulnerable. But what's really striking is the defense's suggestion that if she were in a female setting, she'd be fine. The question is, does her environment really justify the damage she's caused, or is that just an excuse for her actions? Let me know what you think. Is it the environment that's pushing her to act out, or is it the person she's becoming?
Okay, so you disagree with that.
No,
Okay.
it's not that I disagree. I just understand why.
Well,
I don't.
well, there's been representations made that it's difficult to place you. Are those true or not?
Those are true. Although DOC has never tried to place me as a female. I realize that their current rules don't allow them to.
Okay.
But I feel like I'm not as bad of a mental health issue as like it may have to be. And I feel like I'm much more, I don't know, I'm here right now in this DOC setting, and it's almost impossible for them to place me because men approach me or men call me faggot, and it's not like a livable scenario. They put me in mental health like for treatment setting, and I'm with people that are depraved, people that aren't lucid ever, people that aren't cogent ever. I just feel like I've been deprived of being like in the real world almost, and as like an LGBTQ person in the real world, I have a community, whereas like I've been deprived of that, and I don't.
You do realize that when you're placed and you're on parole, there are restrictions, correct?
I do
And you
realize
have to
that,
abide,
but
and you have to abide by those rules, correct?
yes,
And you understand that where you're placed, you can't damage property, correct?
yes, I do. I wasn't really in control of myself at the time. That particular placement, it started off very well good. It had lots of staff I could relate to and got along with, and lots of they pride themselves in being a community setting, and it started off good. And then at some point, towards the second time I was released, I'd say like 85% of the people smoke crack. Now I've been to psychiatric diagnosis. I've been psychiatrically labeled for well over 20 years.
Right.
Part of that is having boundary issues.
I understand
They
that.
put all the boundary issues in place.
Justice, I'm trying to cut to the chase. Do you understand, having been incarcerated for 4 months now, that breaking things is not a solution?
Yes.
We also have a letter of support from Ashley, one of Justice's friends, and that was submitted as an exhibit. Have you had a chance to review that?
Yes.
Hearing examiner Saunders?
I haven't had a chance to review that. I didn't receive that. The only thing I received was a review report from the social worker.
Okay.
I just want to put that on the record.
Okay, thank you.
Do you want a moment to review it?
I don't have it.
I guess send
I
it.
don't necessarily know if I have to send a copy of the exhibits to the, there's no duty to send a copy of the exhibits to the parole officer. I don't believe we sent you a copy of our list of accomplishments, did we?
Yes, I did receive that, and
Yeah.
I addressed that because of one of the accomplishments that was listed was a participation in Stonington for 3 days.
Okay.
And I said earlier that was misleading.
Okay. So I think generally what our argument is that although my client has been difficult to place, and although my client has contributed, and I think she would agree that she has contributed to that difficulty to place her because of her conduct here and her prior conduct, she's received no graduated interventions and sanctions, and these are isolated incidents over a course of 10 months of parole for this period. She's been incarcerated for 4 months. I don't believe it's in the interest of justice to essentially sentence an individual who received a breach of peace in 90 days, 1 cocaine urine, and was discharged for rules violations to jail indefinitely. And I also don't believe that not having an appropriate place to place her, part of which is due to her orientation, is appropriate. She has admitted her conduct. Even if we admit all of the conduct, if everything in the allegations is true, I don't believe a full revocation of her parole is warranted in this case. I don't think these violations are so serious enough to warrant incarceration of that period of time. Thank you for your time and consideration.
The hearing is winding down, and the stakes couldn't be higher. We're hearing from both sides, but the question remains, what is truly just in this case? The hearing examiner is about to make a decision. Will they recommend full parole revocation, or will the defense win over the board with their argument for leniency? Could a more supportive placement or treatment program have made the difference? There's so much riding on this, and the tension is building. Stay tuned. We'll find out soon.
Gail Goodman, would you like to state anything else regarding Ms. Su's background and history at
Yeah,
this time?
just really quickly, I think, recent past behavior can be indicative of future behavior, and all the violations that she's had, all 5 of them, you have to take them in their totality. I understand this is just one violation, but there are 4 more. This recommendation, while I think, the attorney used the word draconian may have been making that recommendation at the first violation, not the 5th. I also want to maybe point out the elephant in the room, that there's some reason that Ms. Sylth is currently in a Ferguson gown and handcuffed behind her back in this hearing, which this is atypical. This is not typical. I don't know what's going on. I can only surmise unless someone wants to tell us what's going on. I just think that looking at the totality, her behaviors are progressive, they're ongoing, they're continuing, and regardless of the amount of time she's received as a sanction, whether it's 6 months or 9 months or a year, or she's previously been convicted of other charges and in other violations, this behavior continues to happen. And it's appropriate to take responsibility in the moment when you're in this hearing, but it's inappropriate when you're in the community committing those crimes. And let's face it, that the criminal mischief charge may have been nollied, but she caused $2,200 worth of damage, all because she didn't want to be there. And she flat out told us in the violation report, I wrote it, it was a quote. I said, well, I guess you got what you wanted, because she didn't want to be in Torrington. And she smiled and she said, yep, I did.
May I respond?
May I speak?
Well, one moment.
Please.
I just want to respond briefly, and then certainly you can speak. What she appears to be in, as far as her garb, or whether or not she's in some sort of a gown, or that's not evidence in this case. So there's no need to address that, one. Second off, even if we assume all of the charges, she's charged with damaging property and a breach of peace. Okay, the breach of peace is a misdemeanor for which she received 90 days. I don't think we should jump where her prior sanctions have been 6 months and 9 months. She received 90 days here. Even if she did damage property, we're talking at about a misdemeanor level of value for damage to property at $2,200 here. So we should not be treating this or even thinking of completely revoking her parole. Thank you.
I just want to put on the record, she was charged with a felony. It was nollied, but just because it was nollied doesn't mean the behavior didn't happen.
Even if it happened.
Thank you.
Even if it happened. $2,200 of damage does not require or call for a revocation of her probation, of her parole. Excuse me. Thank you. Miss, do you wish to be heard now?
I wanted to speak to the previous revocations. The first time I was put into Renaissance East, it was very clear that I was going to be very different from everyone there. One night I was approached 4 different times for sex in my room. The staff allowed that to happen, but then what happened was I burned white sage incense and a $1 bill in a trash can, or not a trash can, a coffee cup, and lots of other clients there were burning incense. But because they knew that I was having sex and not really hiding it, they revoked me. The second time, there were 3 not openly, but 3 gay people in the half house, and they were my friends. And I jokingly went acted like I was going to fillet one of them, but I was well over 6, maybe even 12 inches away from the entire time. And a third party happened to see it, reported it, and I was recorded. I requested him as a witness.
As we approach the end of this case, one thing is clear. Justice Sill's future is hanging in the balance. This hearing isn't just about punishment. It's about the broader question of how the justice system handles individuals with complex mental health and addiction issues. The defense has made a compelling argument for a second chance, but the state has highlighted the escalating risks posed by her behavior. What do you think? Should she get another chance at rehabilitation, or is it time to stop giving her chances?
So that he could speak to the fact that he didn't care and he was my friend 10 seconds later, or 10 seconds during the entire incident. And that wasn't heard. I feel like if I was in the community, not a DMS setting or DOC, I feel like if I was in a DOC setting and a female setting, I would do just fine. I wouldn't be pressured for sex. I wouldn't be in these ridiculous circumstances where I'm pressed to have sex. And I feel like if I wasn't treated like an invalid or like in Parkview, I felt like I was almost forced to smoke crack. I had very little boundary issues, and people would come to my apartment and say, buy crack, buy crack, buy crack, buy crack. And I didn't want to go down that road where I felt like I had 7 months left to live and be healthy. I'm a healthy individual. I just have boundary issues, and I wasn't allowed to have like another person in the apartment to like ward off these people for me. I was forced to be part of a community I didn't want to be part of. I realize I'm responsible for the damage, and that's not the way to go about things. But I was stressed, and I don't know. You know, I feel like if come 2.5 years, if I am, God forbid, sentenced to like my entire parole hearing, I'll do just fine in the community when I'm actually in the community. But I haven't seen anything even close to it in a really long time.
Thank you.
Thank you.
Peter Goodman, anything further?
Just to say that while she was in the community, the last 2 times she's had her own apartment.
And Peter Goodman, I do want to say, I look back at the email chain. You are on the email for the updated list of exhibits for the letter of support. It was sent yesterday around 2:00.
Well, okay, let me just double check. Was it with the other exhibit?
No, it was sent separately. We sent a second batch out.
We're now at the moment of decision. The hearing examiner has wrapped up their findings, and we're left to wonder, will the decision be a lenient one, or will it reflect the growing concern that Justice Sill's behavior could pose a danger to others? As she faces the possibility of being sent back into the system, we're left with lingering questions. How much should the system weigh past violations against a chance at redemption? The final call will come soon. Let's hope this decision paves the way for a just and fair outcome.
Because what happens is my social worker will send in her exhibit. I will review it, will be sent. And then later in the day, I remembered that I had the letter from the friend, and I gave it to our secretarial staff to amend our exhibit. So there's exhibit 1 and exhibit 2 were sent, perhaps after the 2:00 hour.
I did get the first one around 1:22, and this just said I sent an updated list, so maybe I missed.
You want to review it now? It's about a
Yeah,
paragraph.
I'm opening it
Okay.
now.
Okay.
Thank you. Hold on.
Anything further before?
Nothing further from me unless there's comments made as a result of the letter. I just reserve the right to respond.
Oh yeah, here it is. I see it now. Okay, I have read the letter. The only question I would have is I don't understand what is being referred to regarding being forced to take medication. She was on no forced medications.
No, I understand. I don't believe she was on forced medications either.
So that would be my only.
We're not. We don't support that position.
And I also want to say that the Parkview program isn't DMS housing. It's run by the mental health. Sorry, I don't know the exact terminology. 1 second for it.
Mental CT.
Yes, yep. It's run by them and it's funded by DMS, but it's not DMS housing. It's independent living. And she was more than welcome to have guests and company. They just weren't allowed to sleep there.
No, I wasn't allowed to have any.
I think we're
Yeah,
going off target now.
I agree. Yes.
Okay, I don't think that necessarily requires a response. I don't believe that, unless I'm wrong, hearing examiner
Regarding the
Saunders.
charges.
No. Okay,
Yeah,
thank you.
Thank you.
Okay, nothing further?
Nothing from the defense.
I recommend revoke and reparole on February 25th, 2025, which is an approximate 10-month sanction. This is Ms. Thill's 5th parole violation. While on supervision, she received 1 misconduct for testing positive for cocaine and accrued an additional conviction and was unsuccessfully discharged from her programming due to her behaviors. I recommend the following conditions: no consumption of alcohol, no contact with victims LM and JM, halfway house placement, and mental health treatment. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on September 12th, 2024. The board may lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended. If the board decides to impose a sanction longer than what I have recommended, then a supplemental hearing would be held. Before the hearing, the board will provide you with written notice documenting the specific reasons why they might want to exceed my recommendation. During the supplemental hearing, you will have an opportunity to respond to those specific reasons while in front of the panel of the board. This concludes the revocation hearing.
Okay, so Justice, give me a call on September 13th, and I will let you know what the board decided. The recommendation is a 10-month sanction, which is 1 month longer than your prior longest sanction. Okay?
I have the main part of my disability is temporal. Like I'm not gonna remember like the date of this like 3 seconds later.
Okay.
Like 3 seconds after. Is there any way you can mail me that date? Or
They will be mailing you a copy of the results once the board meets on the 12th.
thank you.
This is not a
Officer
final decision.
Officer Saunders, you said February 25th?
February 12th.
Oh,
I'm sorry. So February 25th, 2025. Yes. And
Thank
then
you.
September 12th is the board review.
Understood. Thank you so much.
Thank you.
Thank you, Attorney Famigletti.
You're welcome.
Have a
Just
great
give me
day.
a
Bye,
call if you have-
Justice.
Thank you.
Justice, give me a call if you have any questions.
Okay,
Justice, be well, okay?
I'm trying.
All right. We'll see you soon.
Mhm.
Bye-bye.
Hey, they're done.
And that's the verdict, folks. Justice Sill's parole is not revoked, but the board will review her case in 10 months, a decision that could shape the next chapter of her life. This case highlights a key issue in our justice system: the balance between accountability and rehabilitation. It's a complex issue, and today we saw both sides of the argument laid out clearly. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.